So we have discussed the concept of cooperation, then we discussed the how to incorporate a company. Probably you are well aware that to incorporate a company such as working in Sri Lanka, right? Then we discussed about the articles of association, object clause, the effect of object clause, and then we discussed about the shareholder, their rights, right? Right to vote, right to dividend, right to surplus assets, and their liabilities. Here the shareholders' liability is limited. However, that depends on the type of company, right? And then we discuss about the long-term finance. I wonder whether we have used that topic. Have we used that topic? Have we discussed about that derivative action and only have discussed it? Case, then we can discuss on the first topic today. Company director. By company director. How many directors and directors are in the staff? Yes. Any? Yes. You are director of company. None of you have a private sector company. They one day, ne? So, ne? You are also going to have to do it. You are the director and that's what, right? So, anyway, you all can have your own private sector company and you can be a director of your own company. Right. We discuss about what I asked you to discuss. What did we discuss? So there was issue, I think, just with the Japan government. There was a question whether Yoshikane was a director of CSA. I think that is not yet solved. Whether Yoshika was a director of CSA. Probably online people, can you hear me? Online people, can you hear me?
Yes, sir.
Right. So still there, so I think whether he's a director of that company, probably in half an hour's time, you can decide it. Whether he is or he was a director or not. What do you think? Who's a director? Name the form 18 of the someone who sign and file form 18, then definitely they are director. So according to him, the directors are properly appointed people by filing form 18. Okay. Yes. What's that? Are you all doing it? Yes. Okay, a person who is responsible for our business of a company. Okay. A person who makes company The person appoints by shareholders are content. There was one person who was great for more than 100 content. If I'm not incorrect, list of 188 content was right today or yesterday, right? But I was right. It was a great of 188 content. That's it. One time in that. He said that one time he owned about 40% of the building of Colombo. The example in Sri Lanka, the relationship of business and government. Like, so directors. So some people believe that directors are the people who are properly appointed, someone like filing Form 80. But some students believe if a person is responsible for the company's decision and decision making, they are directors. So just take the normal meaning of a term director. You can have a legal meaning under the company's plan. Right? Normally what the system.
One elected or appointed to manage the company's business and
That someone elected or appointed. What?
manage the company's business and affairs.
To manage the company's business and capital. Okay. Another thing. Yes. The person who control, manage, and direct the company affairs is the director. Interpretation of the company. Yes. It's the same what we got. Person who starts a company. Now you can also look at the interpretation section. Section 529 of the Companies Act, interpretation section, tries to interpret the term director. This is the comprehensive interpretation. A company director is treated as a office of the company, right? So the term officer in the same section, when it interprets the term officer, it says officer include manager, director, and secretary. So officer company director is considered as an office of the company, right? So as officers, we're going to discuss about the directors, secretaries, and auditors. So after this lesson, so next week probably we will discuss about the auditors and secretaries. Auditors are generally not considered as officers, but for some purpose they are considered as officers. For the corporate governance, auditors are also there, right? But for the company law, auditors are basically employees. They are independent people. They are employees more than the officers of governance. But under this whole topic, as all, we're going to discuss about the directors, auditors, and secretaries. So today we're going to discuss about the directors and their role. So we'll discuss the directors, meaning of director, different types of directors, the requirement of directors, the minimum and maximum number of directors, their qualification, appointment, removal, and yes, powers of directors, major transaction. As a second part, we will discuss about the director's duty. Yes, these are three main topics that today we discuss about the director. Right. So, section 5 to 9, interpretation section, interpret the term director. Accordingly, there is a very wide meaning for the term director. Right? So, it says director includes the person occupying the position of a director of the company by whatever name. Therefore, a director is a person who occupies the position of a director by whatever name form. Therefore, it clearly says name is immaterial. Name may be director, managing director, governor, manager, John Paul, whatever. Name is immaterial. What is important is their position. If a person is in a position of a director, then they are director. Then what is the position of a director is a question. Then we have to look at the case. According to the judgment, it is decided that if a person attend the board meeting and take part in decision-making process at board meeting, that is the position of a director. Therefore, if a person attend the board meeting and take part in decision-making at such a meeting, so that is the position of director, then they are director. Therefore, clearly very wide meaning is given for the term director. Right? Even under the common law also recognizes two types of directors as the jure directors and the facto directors. That's a common English common law, right? English common law recognizes two types of directors as de facto directors and the jure directors. De facto directors means the directors so properly appointed. Like you said, if a person filed a Form 18 and name is in the application form, then they are so properly appointed directors. As an example, people who are appointed at meetings, passing resolutions by shareholders and filing Form 18. So they are so properly appointed directors, they are known as the jure directors. De facto directors means directors, they are not so properly appointed. Therefore, there is no law that directors should be properly appointed at meetings by shareholders. Directors may be so properly appointed people or not so properly appointed people. Therefore, it is not only the people who properly appointed like Form 18, right? If a person is in the position of a director, even though they are not properly appointed by shareholders meeting, it's still law considers them as a. So therefore, this common law recognition of the directors, whether they are properly appointed or not, is recognized by the Sri Lankan law as well, saying that director is a person who occupies the position of a director, whatever name. So they are Form 18, 8 other. What is important is their position. On the other hand, even though a person is named as a director, he is not a director if he is not in such a position. As an example, there are some private organizations, they have some attractive office name, like director finance, director transport, director transport for a board meeting, board group meeting. So his position is director staff, but even he doesn't know we are the board. Therefore, even though name is director transport, he is not a director. It is not a position of a director. The name is semantic, right? Nama director not director in the Nama director narrative, no in the so what importance they are position. So thereafter it gives again the extended meaning, right? So it's further says Ramai director include a person in accordance with whose directions or instructions a person is accustomed to act. Sometimes they are also known as directors, right? The person in accordance with whose directions or instructions a person is to act. Say as an example, sometimes when bank offer huge amount of loan to company, sometimes they request we also want a face in your board. Board to get face we going to grant this loan amount. In such a case, instead those creditors are there to safeguard their income. Whether the company's decision affect their credit amount or what, right? However, to get the loan facility, the bank will act. In such a case, there is a person who is nominated by, in fact, bank to represent their interest. So they are also become the board member. So they are not as the nominee director. And also, a person in accordance with whose directions or instructions the board of the company may be required or is accustomed to act. Here, the board is there, right? But board is instructed or advised by someone else. As a practice, board follow their advice and instruction. Then the law says he is also a director. Yes, he may be a shareholder, he may not be a shareholder, right? But we address the board, what to do, how to do it. Board as a practice follow his instruction. So he is also a director of the company. In some cases, they even deal with some other third party by email and all as a chairman and so on. But they never been properly appointed. They never been properly appointed, but they even exchange email with third parties, change to the third track, and sometimes sign third track on behalf of the company. They instruct the board, but never been properly appointed. But they instruct the board, address the board as a practice follow. So law says they are also. So this is an example for the BSAA. Right? They will never be so properly appointed, but they instruct and board that instruction follow their instruction. So law says is also a director. In fact, they are known as the shadow director. Then directors also include a person who exercises or who is entitled to exercise or who controls or who is entitled to control the exercise of what does it say? If a person exercises the powers and capacity of a board, then that person is also a director. Right? If a person exercises the power or capacity which is expected to be exercised by the board, is also a director. Right? This is a good example for something like controlling shareholders. There are some companies, they have more than 50% share, but they don't want to be directors. They don't want to take any responsibility. Right? But what they do is they appoint other people as directors, but they control, they exercise their power. They deal with those other people, right? Because they may have maybe 8% share, but appoint two people who has 10% shares as a director. But they exercise all the powers, so law says they are also director. And also this is an example, sometimes, yes. The final one we discuss a person whom a power or duty of the board has been directly delegated by the board. Sometimes, sometimes the board delegate their powers to a say managing director and ask him to do those things. Sometimes they appoint another person and known as the finance director and gives all the powers to sign checks and so on. Likewise, they delegate their powers to some other director. So if the board has delegated their powers, the act recognizes that the board can delegate their powers. It may be another director or maybe someone like CEO. Right? They delegate some of their powers to the CEO, managing director, secretary, they exercise. Right? So law says they are also directors. Right? So therefore it covers all of them. Right? So clearly it may be so properly appointed people or not so properly appointed. It may be a person who instructs or directs the board. It may be a person who exercises the powers of the board. Right? So they all, according to the interpretation, is the director. Therefore, it is not on the person who is so properly appointed. If they are properly appointed, they are definitely directors. Right? But just because of you are not so properly appointed, then you have not filed for making, one cannot say that they are not directors. The court will decide them as a director if they follow those policies. So now hopefully you all can decide whether that man was the director or not. As another thing, yeah, me. Yeah, left a great name, yeah, form 18 file. That's what he knows, right? Many people, even I don't think the corporate time division. That's a good understanding about the corporate. So this is not such a complicated thing. If you simply know the English common law and the interpretation given by the company staff, within a day they can decide whether he was a director. But probably more than 10 years, not get told whether he was a director. Because if it was a severe, it was as well as maybe a criminal wrong. Because the person who is a member of the Srilanka Navy, the question whether he can be director of the private system. So it was for the simplest thing to decide whether who is a director or not. Right? So the very wide meaning is given for the term director. Then in business world, there are different types of directors. In fact, this is not the legal category. There's no, in law, there are no different types of directors. Law always recognize one party called board of directors, or commonly known as the board. That's the law. And always law believe whenever there are cases, the law believe the board collectively responsible for all the decisions taken by the board of directors. Even though when they impose punishment, they definitely distinguish between the executive directors and the independent director, but they do not accept it as a principle. That always says there are no different types of directors. If you are a member of the board, you are equally liable for the action or decision taken by the board. You cannot take such a decision if you are not responsible. You please resign and go. That's what that is always. The other side can I role like a responsible government. But when they implement those laws and when they make, say as an example, I have seen many cases when there are criminal cases, probably they bail out the independent directors. Only they exist in the executive director. But they do not accept it as a principle. As a principle, they believe board collectively responsible for all the decisions taken by the company. So, in business world, there are different types of directors. As we told, under the common law, there are commonly two types of major divisions. There are de facto directors and the jure directors. That means simply directors, they are so properly appointed, and directors, those who are not so properly appointed. So it is obvious that our law also recognize these two categories. Even in Sri Lanka, directors may be so properly appointed people or not so properly appointed people. According to if there are some people in the board, whether they are members or relations or partners or whatever, they also may be liable as a board member. Then it is common to have two types of directors, executive directors and non-executive directors. Who are the executive directors and who are the non-executive directors? Certain directors are executive directors. Those are not clear certain meeting, but I have not mentioned here one important category. So you can add independent director, right? It's also an important category. Independent director. You can transfer. Independent directors are normally from executive or non-executive. They are different from the non-executive. Executive directors currently independent. Because independent directors, that term is important. Now there is a law that in the PLCs, either two directors or one third, whichever the higher should be consist only of the independent director. Now it is not only a rule, it is a law. Because it says it is deemed that PLC rule is deemed to be breached SEC Act. Act is the law. Yeah,
Executive directors involved in day-to-day management of the company.
So basically, non-executive directors are hired for their expertise. So non-executive directors are hired for their expertise. So executive directors are they are the responsible people for the day-to-day management and business of the company. But in most probably, executive directors are also employees. But non-executive directors are not employees. Right? They are important in a winding up, not in this level, right? In a winding up, that is our last topic, right? So there's a priority for the employees. So there are issues where the directors are in touch for their wages. So when there are cases, sometimes that executive directors are in touch for their wages because they are not only the directors, they are also employees. But non-executive directors, independent directors, they are not in touch for wages because they are not treated as an employees of the company. Especially if the executive director has given a contract of employment, for the winding up law, they are considered as employees. Then, like any other employees, they are also entitled for their wages. But independent directors, non-executive directors are not entitled because they are not considered as employees of the company. So the shadow directors, yes, as we discussed before, shadow directors are the people who advise, control the board of directors. Managing director is also a special office of a company, right? He has dual character. He is definitely a member of the board. Then he is a director. And also he, most probably, 99.99, he is also an MSOP as a man. Right? So basically the board has delegated his some more powers. So therefore, he's in one hand is a director, on the other hand he's an employee. However, if he was expelled from the director board, then he cannot act as a manager. Right? That both have to go in hand in hand. So, but he is a special character, very common in business world to have a managing director. Managing director, yes, many cases decided definitely same type for the wages in the wine because they are considered as a employees of the company and many companies even give them a contract of employment. Their employees are there. So alternate directors are basically appointed when one director is sick or in abroad or hospitalized or whatever to represent him. The board can appoint alternate director. Nominate directors, as I told you before, are appointed by the especially like financial instrument like bank to safeguard their interests. I have not mentioned the independent directors. Independent directors are basically from non-executive directors. So there's a law in Sri Lanka now in PSCs, right? Because it's a CSC rule. Now it has connected to the CSC rules as well. So SEC Act as well. Accordingly, in every PSCs, two directors or one-third of directors, whichever the higher must consist of only by the independent director. And also there's another extended requirement that nominee committee, salary committee, and audit committee must only consist of independent directors. How to decide independence is up to the company. So, only thing is they have disclosed it through their annual report. Some companies believe that if there's no share dealing at all, they are independent. Some companies believe that independent director cannot have more than 5% share. They believe even though they have respectable share, still they can be independent. Likewise, there are different criteria. The company can decide it, however, they have to disclose. Right. So the importance of directors is that company cannot incorporate without a director and company cannot run without a director. To incorporate a company, the company should have directors, and also to run the company should have a director at all the time. If there are no directors, according to the winding up law, it is a ground to wind up the company. If there's no director of a company, then any other person or third party or whatever can apply to the court to wind up the company. Not to have a director is a reason to wind up the company. So that says the importance of the board or a director of a company. So law does not say that company should have a director. Law also set out the maximum and minimum number of directors. What is the minimum number of directors? 1. Private 1, public 2. Private 1, public 2. We only discussed about the two types of companies. We have discussed about number of types of companies, right? Guarantee company, offshore company, foreign company, right? Association, right? But the unlimited company. But something other way. So the law says that public company should have at least 2 directors, whereas any other company should have at least 1 director. That's a minimum requirement of a director. Public company should have at least 2 directors, whereas any other company should have at least 1 director. That's the law. The law does not provide the maximum number of directors, so that can be decided by the articles of association. Take articles of association. Samahala may good governance code 20 is the ideal number of board. Samahala 15 to 20 is the ideal guideline, not the law. 15 to 20 is the ideal. Samanyan 15 to 20 is not a cabinet to not develop further cabinet to 15 to 20. India is another we should learn the business. Lanka, not much better. Now there's a low education and low political attack. Like political attack, cabinet minister. Because in cabinet minister, at the end, our space minister, Namadala, if they then government together. We have a money, I got our image neck. I mean, to the under the block, take a pass over the party of the Ferrera. This is about this period in Paku. Saman and Mother about this stuff. We come to the so forcefully against the law. Ideal number of board is the 15 to 20. So, however, there's no maximum number of directors. It is to be decided by the company. Some companies, by its articles, they provide the minimum and maximum number of directors. The only law is that they cannot have less than the company's act. As an example, public company cannot have one director as a minimum number. It may be 5, because minimum says 2. Therefore, it could be 5, but it cannot be 1. Then the Act also set out the qualification to act as a director. In fact, yes, if you look at the Companies Act, there's no qualification list. It set out the disqualification to be a director. Disqualifications are here. Qualification is right. If you look at the section 202, you will see that there's no requirement of formal educational or academic or professional requirement. There's no such requirement under the Companies Act. Disqualification or qualification is about to be for what? Level passing, level passing. There's no any academic or professional requirement to act as the director of the company. What do you think about that requirement? Does it say that any person, any place, any place can act as a director? That was a question, I think, 2 years before. 2 years before, my question got died. Anything, idiot. So any person who is in charge of human resources can act as a director of the company. Physically coming from 20 months. Say what the question is. Not couple of studies. First section, I get what do you think? Is that true? Can you act as a director? All of you? No? Okay. You can't be a director. You. According to this requirement, if you are over 18 years of age and is in good mind, then you all can act as a director. over the other day, then you all can act as a real. There's no requirement of any professional law, academic qualification. What do you think? Is it good to have some type of qualification? You can compare it with our next two topics, auditors and secretary. When we discuss about auditors, there are proper professional academic requirements. So as the secretary. What is the members of SIMA, and law, the members they are the people who can act as a secretary. To act as auditor, must be a member of PA. But there's no such requirement to act as a RA. So what do you think about that requirement? Is it good to have a sub qualification? My question was that it is good to have some professional it's really good that you have almost 50-50 years. The class is almost 50-50. Some says yes, it's good to have qualification, academic qualification. Some says no. There's no such requirement. So anyway, the people who drafted the Companies Act decided there's no requirement of such qualification to run a business. We all know this is a bank of country. So probably yes, I always apologize for my students. So we are contributing for that. But we expect that we will make this country a better place. But honestly, I have doubt. But so what I want to tell you, whom do you think are most contributed to that situation? Whether it is those farmers and so uneducated people or people like us. But I thought they definitely those so-called educated people who made or contributed to make this country a better country. So honestly, I realize that there's something wrong with those type of professional education. Under Metalan, it's largely contributed by the education piece to make country better. So I think that is the good idea not to have a such qualification, because I don't think that there is a relationship between the professional education qualification and the business. But I think it's those the master, Mama, after taking the business stuff, the not easy to do this. If people know it, they will respect it more than they do. And the business is not easy. So that is so in the world and also in the Sri Lanka. Lanka was a famous knowledge. That's Mudala, Purami, Mudala, now Mudala. Those are the business plans in the country. None of them have either professional law, proper education. But they not even the partner. So therefore, there's nothing to do with the business and the work. ලෝකේ ගත්තත් එහෙමනේ. ඔයාලා මාර්කට් ප්‍රයිස් එක ආවම යන්නේ. ඒගොල්ලෝ වික්ටේ කම්ප්ලීට් කරගන්න අපස්කාර දත්තකට ඒගොල්ලෝ ගාව වැඩ කරනවා නේ. ඒගොල්ලෝ සර්විස් කරන්නේ ආවල් එකේ දාලා ඉඳගෙන ඉඳලා market maybe anyway. So there are some people they are better than. I think that is right. There's no such requirement to have a proper formal educational law, professional qualification, but it doesn't mean that criminal people, thieves, idiots can act as them, right? When you go through that, you will understand there are some proper people who have a good business mind, right? It doesn't say that just because of there's no requirement of professional law, academic education, you can't say that they are thieves and robbers and so on and so on. Right? So it is evident to go through the requirement. To act as a complaint debtor should be at least 18 years of age. Therefore, it says that some type of maturity is required. Minor cannot act as a debtor. Anyway, age of 18 is the age of major, right? At least you can't enter the contract if you are not 18, right? And it says that there will be some type of maturity to act as a complaint. I hope even countries like Sri Lanka that could make even 20 or 21 to be the date of PA. In Sri Lanka, our countries people, next, which are Galle, can get some money for a money. Appeal some other value, then get no reward. These are Lanka, PNC, we see that not come, right? It requires some type of maturity, right? And when you look at the others, yes, an undischarged insolvent. So insolvent person, bankrupt person cannot act as a director of the company. So if a person is prohibited from being a director under the current law or previous law, they also cannot act as a director of the company without the license from the court. So the Companies Act can prohibit people act as a director if they are convicted by criminal law. Therefore, those criminal people who have conducted criminal offences cannot act as a director of the company. So, law also cannot disqualify people with the director of the company if they are convicted or if they were wrong or charged with some fraudulent action or some misstatement or untrue statement in the prospectus. So in such a case, the law can prohibit them acting as a director. Therefore, it clearly prohibits people who have a fraudulent mind cannot act as a director of the company. And also, if a person is alleged to be of unsound mind, so insane person also cannot act as a director. It has to be proved by the court. Court hardly decide the person as an insane person. It is our district development clear. Still you can act as a director. It has to be decided by the court. So the class who decide the some bad stuff by insane Hadikela. We should be what they are. It's a father of the hour. You want to have good mind can act as a director. Because the case of the one turning, if Galle at the parliament to answer the exam, I will check them off. Right? We have to get a market for low on that. You can check the right? But it takes that case of starting again. We take that. Because I say, may the take the like, you know, that good care again. I can only take the lucky. ඒවගේ කලාතුරකින් තමයි මේ උසාවි පිටුවක් දෙන්නේ. බෑන්ක් අපෝ ඉන්ෆ්ලේෂන්. ඒ උසාවියෙන් දුන්නේ නැත්නම් මිනිස්සු පුර ගන්න අසුරන්නේ. And then not a natural person. So only a natural person can act as a director of a company. What is meant by natural person? Huh? Only natural person can act as a director. What does it mean? In fact, yes, the corporate for there are two types of people. The company recognize two types of persons are artificial person and natural person. So natural person means individuals like you and me. Artificial person means corporation, company. So director, company, corporation cannot act as a director. Only individual can act as a director. That's what it means. Right? Say as an example, company can be a secretary. Firm can be a auditor. But director, no firm, no limited company. Only a natural person can act as a director of the company. The company will have to see artificial, natural. I mean, person can have it may be either natural or artificial. Because artificial person can be either right. Make after a month, chance to go for a teacher training. Teachers that are BSP on it, common and those and a contact but the point and lower than the line. Tell us that the other one, yes, sir. They can go to marketing teachers and they have great respect for them. Up in Lanka, and then copy one of you. Games among at the past, people should have a keeper for a young, both green and food. Half loan insurance partnership company one clean biggest low. Go over the theater board. Not a natural person in a gallery. I saw about to put because I thought explain under the put the එකක් විතරයි ඔය වගේ දේවල් මාරු දෙයක් තිබුණා ඊට පස්සේ මම ජීවිතේට කියලා පාර්ට්නර්ෂිප් එක හැමදාම දෙකයි ඉස්සර කියලා දානනේ මම ඒක වැරදි පාර්ට්නර්ෂිප් එක දෙකයි ඉස්සර කියලා ඔයාලට පුදුමයි ඇති එහෙම ගන්න එක පාර්ට්නර්ෂිප් එකේ maximum numbers are limited to 20 by companies not by the partnership but it is imposed by companies section 5191 5192 says this section will not apply to a professional partnership. After a partnership, they should have been a professional right. They are out there. So, we get one partnership national limit. This year, not in the front, see us not in the front member. This is a general trade partnership. Have I opened the country? Hamadam 220 Lapun. This area will some modification. A Qatar in that process partnership. Future company, public company, continue not for members. Take a half of the pilot taken a happy, not public identity. Half of the limited company, other application, we over the aircraft, they decide account to it. Public company, then it doesn't incorporate the name. Public company, then incorporate the name. They would not run the business. Have actually had in it. We also solve it now for private company, single share out of companies are permanent. We also have a monoscope. Company decide certain that we have a done paper. You are done ban and is other than well, if I read the gave a paper, other than not only that BSAA, this is Lanka, also. Lanka, Art commerce and fail you na alla the hand to take a given. Next science the Assam is a complete. Who gets the and the next time on the planet, Dawa out the weekend back. Normal language. The maths bio transplant. They were again out 1995 physics coming some other outdated. I apologize on it, but the months. Master Lamai Lago for the Ganan Rasan, they are not telling for them. Calculation no command here, one calculate our put used to be Islamic they search and unknown to my ඉස්තර ලඝු බලන්න මෙන්න මේ වගේ ඉන්ටර්වියු දාගත්තා කියලා ලඝු පොත ගාලා කොහොමද දාපු පිටුලා ඒකවලදී පොතේ. ඉතින් ඒක උත්තර වැඩි කාලෙක සුදාරිට වෙලා කියනවා ඒකට කියන්නේ. දාකේ අපිට මේ ලඝු පොත ගාලා බලන්න මෙන්න මේ විදිහට එකක් දාගත්තා කියලා ෆොටෝ එකක් ගහලා. අපේ උන් ඇත්තටම තාම ඉල්ලන්නේ ඔය ලඝු පොත දාන්න. ඒ ඇති මා ලකි you can use calculator නේ. Itu super lagi itu. Atau memang ya ada kita lagi amat mengalami dua minggu kemarin kalau itu betul. Saat terakhir profesor yang itu mengalami yang mana. Lihat jadi program project pas lagi. Ini dia ada tahu kau mah hebat aku. Memang betul betul. Kita expect boleh. Kalau betul ini berbeda ini. Kita kalau kau selain yang nanti dalam juga sebab ini management itu tak ini ada untuk yang lebih tinggal di awal mas ini bisa tak portfolio kami pilih nanti akan dapat luar yang kami ini suatu anggaran ini kalau kita pergi kami anggaran orang yang kita baik sama gana kata kata kalkulasi saya use kerana anggaran ini nanti kami orang yang kita baik gana kata ini even I don't know how to use the calculator jadi ni අපි කැලේක යූස් කරන්නේ නෙවෙයි. දුකාන්දරය යදපොත්. අපි ඕන හතක අක්කු වල දෙනකොට ඒ වල කැන්සල් ට්‍රාන්ස්ෆර් කරනවා. දැන් මේක හෙඩ්ෆෝන් එක දෙක දෙනවා. Right. එතකොට yes. Only natural person can act as a company director. And also there may be some other requirement imposed by the articles of association. Right? By the company's articles, they can require some other qualification. Or not that the to be a director of so and so company, they have to pass the level. Whatever they can have their own qualification. But there is sometimes there are some requirements like to be a director of this company, they have to get the share qualification. Share qualification is that means to be a director of this company, they have to buy some minimum number of shares. It is called share qualification. To be a director of that company, you have to buy the minimum number of shares. Then only you can be a director of that company. That type of requirement may be imposed by the introduced by the articles of association. So those are the qualifications to have that director of company. And also court can disqualify people, person being the directors of the company. That's why if the person is charged with criminal offense, if they are charged with fraudulent action, if they were decided guilty for having untrue false statements in the prospectus, then court can disqualify. Therefore, thieves or fraudulent people cannot act as a director of the company. There are provisions to minimize them. And also, you know, there are some requirements to have a independent or non-executive director. Therefore, if a company believes that they need the expertise or some people with some qualification, then they can fill their gap with that requirement, right? So auditors, doctors, engineers, lawyers can be appointed to the board using that requirement of non-executive or independent group. Then it will be a good combination of so-called educated and business people, right? So that is why law believes that there's a mandatory requirement of independent labor. Therefore, then it will be a good balance board. Right? But so that they have to use that knowledge. Everything able to then naturalist එකක් නේ ඒ වගේ එකක් කියන්නේ. ඒකට දැනටම හරියන්නේ නැහැ නේ. ඒක කොම්පියුටර් එක්ස්පර්ට්. ඒ වගේ තමයි සස්පෙන්ස් ඩිරෙක්ටර් බෝඩ් එක. ඒගොල්ලෝ දැනගන්න ඕනේ. දැනගන්න බයිලේ ආසයිටි වගේ කරන්න තමයි. තමයි කියන්නේ. So ඒ වගේ තමයි කම්පල් බෝඩ් එක ඉන්ඩිපෙන්ඩන්ට් ඩිරෙක්ටර්ස් ඒ ගැප් එක තියෙන්නේ to fill that vacancy with the expert. So they can have that expertise with the independent and non-executive director. Can we continue? You want to break? Take a break. Like over here. Like make this, I think, how to appoint break? Break, I don't mind, even every hour you can have a break, but have a break and start with the how many times after start that we might go to the KBU, especially the KBU masters and all. They take break for every 45. I'm a 45 minutes for every break. After every somehow that is not a different experience. The only thing is that sometimes people feel that they are not educated, that's when some of them are really educated. Some of them they do want to get the info. Especially Geo. I mean, it's a Harappa and we have put my actor. I don't know. I mean, people get the Arthana. They will really have to have the start of play capital. Somehow, after wonderful care, in my town, to get a activity. Like other protect to get a protect to get up. After subject like English, subject is the other given some other use the low every subject is only one. Low I see 1 hour gain like you got the final those have a subject 1 hour subject. So when I come to Japan, then only I use that they have a 3 hour day. We never had that. Okay, 1 hour. I'm going to take up 1 hour. But this is really effective. Actually, last year, you one in the life data, you will like data, very effective. Like, how to appoint directors? How the directors appoint them? Now we are going to discuss about the formal appointment of them. Yes. You know, in company law, the powers are delegated between the management and the owners and the board of them. So some powers are given to the board, some powers are given to the owners. So even though we say that the powers are divided between these two groups, in practically, director's role is different. Their powers are, I mean, it's almost absence of control. That is because the wide powers given to the board of directors, and also even though we say that it is separated ownership and the management, the practice is now it is the main shareholders who become the members of the board. Or at least they have a close relationship with the majority of major shareholders. These are practically happening in our shareholding in the board. Major shareholders are board members of the. And the shareholders also exercise their powers at meeting. All the meetings are held, dates are decided, proximity is checked, all are done by the board of directors. Therefore, it's not easy. Underwater, directors. So therefore, it's not easy. They have a very wide powers, and also there's no rule that board has to follow the instruction or advice of the shareholder. Directors are not bound to act according to the wish of the shareholders, and it is not legal. It is not anything about it. As long as they act according to the company's act and the articles of association, there's no rule that board has to follow the wish of the shareholder. But again, constitution used to be the constitution as long as they comply with the articles of association and the compliance, there's nothing wrong. Therefore, they have a very wide power. However, there are some occasions where always there's a strike a balance. Check and balance is a part of law, right? So that is why it's divided between these two groups, at least as a theory, and some powers are given to the shareholders. This is one such a power that shareholders, owners can control the wide powers of directors. The controller who will appoint the director. With the powers of the shareholders. Shareholders will appoint. They also have a power to remove them. They also have a power to decide their remuneration. And there is an independent director. So those are some ways where they can control the wide powers of directors. Right. So directors are appointed by whom then? But anyway, there are two types of appointment. First appointment and subsequent appointment. First, all initial directors are not appointed by anyone. To incorporate a company, you have to have a director. Before that, there are no board meetings or shareholders meetings. Therefore, first directors are not appointed by anyone. The person whose names are in the application form to incorporate a company automatically become the first directors of the company. They are not appointed by anyone. So they hold the office until the next AG. Therefore, first directors are automatically appointed the person whose names are there in the application form for amalgamation proposal. Right. Thereafter, all the subsequent directors are appointed by shareholders, passing resolutions at meetings calling for that term. Right. So only the subsequent directors are appointed by the shareholders. So they are appointed at meetings, passing only resolutions called for that term. If there are 5 directors to be appointed, can all 5 appoint by passing one resolution? So it can be proven. There's one argument that all people can be appointed by passing one resolution. It's okay, no. It's unright, one will be. And then by night. How do you do money? It's not like a I went down the road. It's cute. Then I got clear. You know, that's not fair. But in public companies, they should be more than individual. Private solution should be. But in the private company can be private your company, even private director can be appointed by one person. But in public company, it is to be voted individual. While the solution to be passed, it is good thing. Again, when the front of the other director and parliament, so therefore it should be voted. Okay, you take a break. थोड़ा 10 मिनट का सेमिनार हमारे यहाँ पे कितने हैं? 5 से 3 दिन 10 मिनट तक। चार नहीं अगर उसमें As a board, one member is only 17 years of age. Another member is not properly appointed. There are 15 members. What about the decision they make? So they have entered the contract to start a new business in India, which must worth million. It is taken with the members of that two people. One has not proper qualification, one is appointed improper. What about the decision? What do you think? What's the validity of that action or contract the board entered? No way. Valid or void? Valid. It says void, then that will affect the main people. They people contract in the government. Valid, then they will be happy for the contract, but they are not properly approved. No, wait a minute. If a president was wrongly elected, what will happen? So basically, that pension will be stopped about 1 year. After 1 year, it is decided that he was not properly appointed. Then what will happen to the decision he made? Yes, that's the reason one Sri Lankan government Chinese saving loan from is unlikely to reverse. So therefore, even though they are significant, whatever, the action he has done are considered valid. From that day, he said, everything will happen even for that money. So Mohammed Sibla was removed once Sri was in power. Otherwise, Mohammed Sibla appointed how the Srilanka Pradhan Nayak Mohammed Sibla appointed. India policy, ඊට පස්සේ 1 year වලින් ගිහිල්ලා යා ලයින් එකට කිව්වා මම අයිමුත් නෑ මම. ඊට මොකද කළේ? Jan Bandai was against this, saying that Mohan Sibla never been appointed to the post because he was not properly appointed. He was properly appointed to the Jan Bandai අයින් කරන්න පාර්ලිමේන්තු දේශනයක් අන්දුලා මෙයාව අපොයින්ට් කරන්න තුනේ දෙකම වෙන්න. This is Jan Bandai අයින් කරන්න Parliament has passed a resolution. But there was no such agreement or passed resolution to appoint the Mohan Sibla. Therefore, court decided he was never been properly appointed. He was removed again. But that time he was given several things. This unlikely to reverse. Therefore, those judgments he was taken during that time were considered as good judgment. It is possible that in the same way, even though there was the act of a person as a director should be valid, not notwithstanding the fact that the person's appointment was defective. We can hurry it up. The person is not qualified for such appointment, but still decision taken are considered as valid. In those cases, but as a board decision, they are considered as valid. You can also apply the agency law. Agency law is if a third party can reasonably believe that this person or this board has the authority to act on behalf of the company, then the company is liable. Because they act on behalf of the company. Agent even may be a bank person. So, because third parties can believe this board has the authority to execute the company. Therefore, it is not a reason to make such decision invalid. What is the salary remuneration for directors? How much they are entitled to? Directors, are they entitled for wages, salary? Probably the most highly paid people need for the director. But law is such that they are like trustees, right? Governors, right? So therefore, the law believes that they can have salary remuneration whatever, but only if authorized by the shareholder or by the article. If articles or shareholders do not authorize, then they are not entitled for any rupee as a right. Therefore, it's very important that they can have a remuneration commission whatever around, basically they are entitled for the allowance, around someone around around the there are party people yeah, ticket chairman purchase in time, Palianda. Mark. The state relation is to the yeah. Such a part Palia can have. The other master, that's the part of the Lima of the driving. Right? If you are Palia can have Palia, master, that's the part of the Lima of the in many cases, they are given allowance for them, fixed salary or remuneration. So, however, even that, they are only entitled if authorized by the articles or if the shareholders pass a resolution. Simply, directors themselves cannot decide their self. The only way they can do it that it has to be approved by the shareholders, giving the board to decide their self. For that, again, shareholders have to approve that. Or it should be there in the articles of association. If articles do not provide, or if there is no such resolution passed by the shareholders, then they are not entitled for a group. However, we all know articles are drafted by the directors. It is the directors who are also in the shareholders meeting, so they definitely will provide such provisions for their allowance or self. And also, even they can provide the director or former director, right? So they can decide something. But the directors themselves cannot do it. And also how to vacate the office of a director, how to terminate the director's office. Right? By death. By resignation. So at lower for a common day, right? And you are right for it. So the office of a director can also be terminated by removing, by resignation, by replacement. Right? So resign. So it is right for any office that they have a freedom to resign from their office. So as directors, they also can resign from their office. However, there are some rules. If there's only one director, sole director or last remaining director cannot resign. Because if there's no directors, then company cannot run. Therefore, if there is a sole director or if there's a 10 directors, 9 directors can resign, 10 one cannot resign. If the last director or sole director want to resign from the company, then they have to call a meeting, appoint another director, and then only they can resign. Because if there are no directors, it is a reason to wind up the company, and also company cannot run. Removed by the shareholders. So directors are appointed by the shareholders. In the same way, shareholders can remove directors from the board. How can they do so? Again, the same way. At meetings, passing resolutions for that purpose. Right? At meetings, passing only resolutions for that purpose. individually like and become disqualified from being the date of the company, right? The court can disqualify people, right? If they are done some fraudulent action, right? If they have wrong, fraudulent, untrue statement in the prospectus, then court can disqualify such person being the date of the company. That way, court can disqualify people becoming the director. Or by death. Or vacate of his reaching the retirement age. There's a retirement age for the director. What's the retirement age of the employees of this country? Public employees? 60. Private employees? 8. Lanka को बैकअप होना से मतलब में बिल्कुल अलग तरह से आता है, स्पेशली पब्लिक सेक्टर। बेटा में तो लागू बात उन्हें तो पता गार नहीं कि साव आउट द सिस्टम तो देखा सिस्टम ने फ्रॉम क्लियर ना तो प्रोसेस तो पब्लिक आते हैं अन्य देखो अरे ये अल्लाह से मैं फीचर्स ला ओ कैसे बना दे पाए वो मान गया था आउट द देखा डिटेल के रहा है तो वहां का बात है ये बनाता बैकअप मान के कौन इतना बांधता है सामान्य Lanka retirement is a hurry application. However, now it is switched okay, right? So, recently we had a party and over the now it is 60 bits again some modification. This was the half of the head of Doctor and other thing on that category, and it has to be at the country as come to school and activity. But that you not work after the very Hospital where the country the high road band again on it, because of the high road here. Now we'll read hard here with the band. So probably there's a case to the form. I hope that will also be extended unto at least 60. So nice of we have a very powerful but untied Samani Hatai. Lanka had a pay the civil document also. It has Sudasana had a pay never done nothing. Full teaching of the age. Supreme Court judge 65, judiciary lecturer 65. They will not go and do the Supreme Court into the batch. Have a fun now. Play Lamayuta. They will not go and put on and tell Samane. He could have Panahai then later. Now there's no difference between private and public. For the public, now it is 60 with some modification, and even for the private sector, now there's the retirement age of private sector employees act accordingly. Even for the private sector, now there's no difference between male and female. That is also decided as 60. These are the private public and male female 60 is the retirement age. That's a performance on that. Like I have a budget. Kamala could have there. Then marriage you not private. Lanka had Lanka and India, Makaran delay. It's a someone has because they change their offices every 5 years. Except that I know what that one has to back up the one Lanka is non-Japanese speaker, not man the company. So we come here after safety. It's starting again. They were a user for the internet, found in the out of 5,000. Where soon as you always get fresh mail. It's a health of people who are recommended in the month and have a particular Lanka. And Lanka former three others again, you family and Ramaya idea for internationally last money. But we can last letter method Mama, I don't think I made it for the one the Kapala and I think I put the company and I told the couple last song in the I think able to young at half, and I don't know, I you do that in the people are living at the Mother actually reception. They go back. Last is there are last name. I was able to analyze it as able to balance not regular sexual activity in Nago. Like England, not again. I think you are very sexy. You are. Thank you again. Therefore, that only applies to the public company. Public companies and private companies if they are subsidiaries of public companies. So the general private companies, there's no age limit. That's one reason for the people to have a private company. They can be a director even at the age of 100. For the public companies and subsidiaries of public companies, directors have to retire at the age of 7. However, there may be some people, they are fit even at the age of 7 finish. Somehow, if they want their service, but they can do. Do they have to retire? Yeah, research data to like actually people use something like medical pension again. So it on the patient, I'm getting a so much for you to get. So now, as you pass the medical, I will take up for the individual one. Then you enter for his pension. You do like pension. Somehow the idea came American. So yeah, I will begin to men or rather with the bride, who are to pension. How you cannot attack lower cake will have a spout non pension. Then I knew I did. That they are a common army gave of the Sankaman, Saman pension, they are going medical. They are a pension, they are the spout. They are also from our daughter. Amount of others pension and all other pension again. I think I'll do for pension from me about the Islam mention about the common, maybe nothing. Worst case, he come on now. The pension again, what if there is a person who is over the age of 70 but is still fit, but the company won't be service? Is there a way to get this service? The company has to pass a resolution saying that this section, section 210, will not apply to this particular director. The company has to pass a audit resolution stating that this section 11 to the age limit will not apply to this particular then this will not apply. Then that director can be appointed for another year. But that appointment is only valid for 1 year. Otherwise, some directors even can be appointed for life by others. But after the age of 70, company can appoint them, but that appointment is only valid for 1 year. But if they still believe that you want the service of such a person, every year you can pass such a resolution and can be a director of such company even after the age of 70. Or maybe according to the Articles of Association. As an example, some public companies, the Article of Association says 1/3 of board should retire at the age of every 3 years time. Then every 3 years time, 1/3 of board has to retire and new people will be appointed. Therefore, when there is such a requirement by the articles, then again, according to the articles, those people have to retire. So that is how the office of director will be terminated. Right. Now, the powers of director. Who are the directors anyway? What is the role of director? What do they do? As we discussed in the very beginning, they control the business, they run the business. So, what's the relationship between company and director? There are so many judgments. What type of role that do expect from them? What is the relationship between company and director? So that is again, it's very common in law that very difficult to define exact role of a director, because that depends on the type of company, the relationship with them. Right? Say as an example, director of a private company, they are almost all the shares belong to that person. Maybe completely different from the role of a public company. Where there may be no any share deal. The private company, maybe the sole owner and the sole owner. So that responsibility may be completely different from the independent director of the public company. So therefore, very difficult to exactly define their true role. That's the thing. But according to the merit of each case before the court will decide what law expects from them. There are some cases where the court decides the director's role is similar to a role of a trust, because they protect, develop someone else's property for the betterment of someone else, not for them. They protect shareholders' property for the betterment of the shareholders, not for themselves. So it is very similar to a role of a trust. Trust is someone in there are some cases they have decided, therefore, what law expects from is the role of a trust. But there are some cases again they say it is not 100% similar to a role of a trust. Because in a trustee or trusteeship, that property belongs to the trustees. It is not the managed. But in company, company's property belongs to the company, not to the trustee, not to the shareholder. So for you, how in trustee? If I look at 100% trustees, and also under the trust law, trustee can be sued. But under the company law, as long as they act within the powers, they can be sued. If they act beyond their powers, then they can be sued. But as long as they act within the powers of the director, then they are accepted, then they can be sued. Therefore, there are some difference between the trustee and the director. That's why in some cases it is decided that they are only similar to a quasi-trustees. Quasi means half, the half trusteeship. But commonly believe that their role is similar to a role of an agent. The director's role is very similar to a role of an agent. Because they act on behalf of their principal, company is the principal, board is the agent. Because company cannot get their things done, therefore they believe there must be someone to get their things done. In most probably it is done by the board of directors. So therefore their role is very similar to a role of an agent. So that's the most similar or most closest relationship between the company and the directors are their role as an agent. So their duties are very similar to a role of an agent. But in strict sense, again, you can say that they are agents. Strict sense, again, because according to the agents, you know, agents never will be liable. Principal is liable. But whenever there's a breach of contract, right, as they act beyond their power, then there are so many provisions in the companies that directors can be sued. Under the agency, you can't sue against the agent. The company in the past now, okay, by inside two sensitive agents but it is really similar to a role of an agent. It is difficult to define their role because of the business is very wide. You never know. Sometimes you know the non-profit association and the PSC completely different. Therefore, you cannot exactly say their role. So it is a business term that depends on the business they do and the relationship between company and the board of directors and what they expect, right? And their contribution and the type of company. So all of them will decide their true role as a director. So, however, one thing is clear that the board has a very wide power. They have a very wide power when on the company. Section 184 says the business and affairs of a company should be managed by or under the supervision of the board of the company. Therefore, company's management and business must be done either by board or under the supervision of the board. Therefore, owners have no say in the management of the company. It should be given or done by the board. That's the one major difference between the concept of corporation and other type of business. Whereas in any other business will be run controlled by the owner. But in corporation, company, owners have no say in management. It is clearly given to the small body called board of directors. And it further says the board of the company should have all the powers necessary for that purpose. Right. Very wide. Again, here, management business can be done supervision clearly powers capacity for the so they are very wide power. That's why I said absence of control. Once appointed, unlikely to remove. Even though we say that shareholders have a power to remove them, it is not easy. As we already discussed, major shareholders are again board of in many companies, sometimes articles give them power that they can appoint the director. Sometimes the shareholders themselves pass a resolution authorizing the board to appoint the director. Few directors will be appointed by the shareholders at the stage year. Thereafter, they pass a resolution authorizing the board to appoint the other balance of directors. Therefore, in fact, in many companies, directors themselves are appointed by the director. Even though we say that it's the right of the shareholder. It is the right of the shareholders to appoint directors subject to the articles. And when bank the shareholders have passed a resolution authorizing the board to fill the casual vacancy. Using that, the board will fill the other vacancy. And even though there's a renewal or whatever, they have to remove at meeting. Meetings are decided, called by the board of directors. Then there's a proxy, they are checked by the board of directors. Therefore, they clearly have absence of powers and once appointed, they have a very wide power from the business. Right? So even under section 184, they are given very wide power. However, so always try to strike a balance between these two groups. Even though we say that the directors have very wide powers, by 184, the immediate section thereafter, section 185 has a very good restriction on that white power company. What is 185? Major transaction. Very good restriction. One of the business transaction, they have all the power for that purpose, but immediate section thereafter, section 185 is, even though they have such a wide powers, they cannot enter into major transaction. But a very good restriction. That's very good line because nowadays, before 2007, at least there was some restriction. Company had to object. So they just had to act within that object. So, limitation. Company but today there's no such object. Therefore, they are powerful very much. Before 2007, there are a number of shares they can issue, known as the authorized capital. The directors could not issue more than that. But today that is also not there. They can issue any number of shares they think. So I'm a white power scheme, right? You know, they are last on the control of the even though we say that they have such a white power, this is a very good section, section 185 that directors cannot themselves enter into major transactions. So that is how the law control. Right? So that's why I said always try to strike the balance between their white powers and the rights of other stakeholders, especially shareholders. So just at the sum look for section 185, but the 16. Thus by section 185(2), it defines what is a major transaction. As an accountant auditor, you need to have some knowledge. Then probably you have to address this. Section 185(2) defines what is a major transaction. 185(1) says how to enter into such a transaction. Oh, I will subject to that. Section 185(2) A, B, C define major transaction in financial. Financial transaction accordingly, if a company acquire or agreement to acquire if a company buy something, if a company buy something, it has effect more than half of the assets of the company. Acquire can buy something. 50% is the negative. Dispose or agreement to dispose. That means to sell something. If the company is about to sell something, it can affect on more than half of the assets of the company is also negative. The monk the only asset we have is a house. That was given to the foreign. He takes the country. The only asset was the house. So he sold. So we have the resolution that is decided to share the property. Then other resolution authorizing the same directors for single shareholder company, authorizing that person to sign the transfer deed. Then another resolution passed by the same person as a shareholder to approve the major transaction. Because that's the only asset they have. So therefore they have to pass a special resolution because it's the major transaction. That's a transaction more than 50% of the disposal. Sale of the land, which has effect more than 50% of the asset. So some people transaction invalid was a single share of the term, but there is a requirement of three types of special resolution major transaction cover resolution another resolution want to sign as a director authorizing him to sign the deed. So directors committee shareholders authorized person will be. So the third one says there's an agreement or series of agreement which can effect of more than half of the assets of the company. So, if it is more than 50% is the major transaction. So it is clearly affect the shareholders and all other stakeholders. Therefore, directors can vote. People majority can vote. It can be approved by 75% of shareholders. That is legal act. Either pass the cut, either put on directors that are outside the country. At the pass, difficult. So 75% shareholders must agree to a major transaction. And now I will tell D the current case section 185.2D define the major transaction completely different, not financial means at all. A world of us says that there's no object clause in the company after 2007. But object clause in the right? If a company changes nature of business, it is also a major transaction. Object clause is right? If should company decided to start sale, is a change of nature of business, is also a major transaction. So directors can do. So that section 185.1 says how to enter into such a contract. Right? For the section 185.1, directors are the approved by major transaction. Contingent to approve by major by special resolution or should be provided by the articles, not amended articles by original article. In original articles, you hardly see such a structure. You can't do the article. Or all the shareholders must agree. Because you see account later. Even original articles original articles saman dane. This account in order right. That's the communication. So this way to such a transaction is to anything to such a transaction with passing is special resolution. So as auditors, accountants, you have to be aware of that. You have to advise the secretary that this how you will be to such a contract. Because sometimes some lawyers secretaries are not allowed. Right. Therefore, yes, it's a very good restriction for the wide powers of directors that directors themselves cannot enter into major transactions. So that they need to get the support of more than 75% of shareholders. And section 186, before 2007, there were managing directors, there were nominee committees and so and so. However, it was a practice. From 2007, there's a separate section that authorized the board to delegate their power. Delegation of powers was done even before 2007, but that was not written. It was done as a practice. But from 2007, it says that the subject to the restriction of the articles, the board can delegate its power. Board can delegate its power to a committee of directors. So they can delegate their powers to a nominee committee, salary committee, audit committee. So they can delegate it. It is recognized by that. They can delegate their powers to a director. They can appoint a managing director and delegate some of the powers of the board to a managing director. They can delegate their powers to an employee of the company. They can delegate some of the powers of the director to a PDO. Then PDO has the right. And they can delegate their powers to any other person. Maybe managing director, manager, secretary, right? They can delegate their powers. So it is recognized by that. According to the definition of the director, the board can delegate, but those people are also considered as directors. Delegate as CEO in the front, manager in the front, secretary in the front, they are also recognized as directors. They are also liable for the breach of their duties as directors. However, law says the powers mentioned in the sixth schedule cannot be delegated. Sixth schedule delegate cannot be delegated. But the one wants to just schedule, delegate cannot be delegated. They only have to be exercised by the board themselves. Managing director, communicator, the board they may exercise them. Sixth schedule nothing. Issue of shares. On the share issue, it has to be done by the board of directors. First, consideration of shares. Next, to decide the consideration. Value of the share also has to be decided by the board. Then, distribution. To pay any dividend or distribution can only be decided by the board. It cannot be decided by the managing director or any other part. Changes of registered office. Change of registered office can only be done by the board. The deduction of the state authority is also the registered board. If the company wants to reduce the state capital, that also has to be done by the board of directors. So likewise, those are, the very material thing, very important thing that can materially affect the stakeholders, especially shareholders of the company. They can only be done by the board of directors. Now, if you want, you can have a new meaning for the term. Make up the corner, the proper directors are the directors who exercise the powers that are from Schedule 6. Because they even cannot be delegated. After Galvan, name directors by Galvan, fixed schedule and they were exercised. Here they were after delegate board become and they were proper directors for the company. Because they only can be done by the board of directors. Even cannot be delegated. Right now we have discussed the meaning of director. There's a meaning for the common law and also there's an interpretation under the section 529. Then we also discussed role of directors. So directors' role may be similar to a trustee or quasi-trustee, half-trustee or agent. That cannot be decided exactly, however, according to the merit of each case, the court will decide what law or society expects from director. As it's a business office more than the legal term, so it is to be decided according to the merit of each case. And also we discussed how to appoint director. So director's appointments are two types, as initial appointment and subsequent appointment. Initial directors are not appointed by anyone. The person whose name appear in an application form or an amalgamation proposal automatically become the initial or first director of the company. Thereafter, all other subsequent directors are appointed by shareholders at meetings, passing only resolutions or for that purpose. If there are any casual vacancies in between, then the board can fill that casual vacancies until the next AGM. We also discussed their qualification. In fact, Act has set out some disqualification list. Accordingly, even though there's no requirement of professional or academic requirement, so it says that to do business, we have to have a business knowledge, and the people who mature people who has a sound knowledge of this. And then we also discuss how to terminate or how to terminate the back end office of the director. And also we discuss now the director's powers and some important restriction on their powers under section 185 major transactions. And section 186 now also recognized in Britain that directors can delegate their powers to a committee, director, employees, or any other person. Those delegated people are also can be considered as directors for breach of their duty. However, some duties recognized by Schedule 6 cannot be delegated to anyone else. They are to be exercised by board themselves. Right, so those are the first part of this topic. Then we can also discuss the duties of the director's duty. So director's duties also first time in Sri Lanka are catalogued after 2007. It doesn't mean that there were no director's duties before 2007. They were there, but they were recognized by the English common law. The English common law, English judgment decides the director's duties of Sri Lanka. Therefore, if a person wants to be a director of the company, to understand or identify their duties, they have to look at the English common law judgment. The English law decided the duties of Sri Lankan company. It is not simple for the general layman to go through those case law and identify the director. Under the common law, there were some duties like duty to act in good faith, duty not to be reckless, duty not to be reckless or negligent, right? To use their due care, right? So those were some of the important duties expected from man, from a director under the common law. So first time in Sri Lanka, now almost all those common law duties are now written. So from section 187 up to 200, and again thereafter by special to section 219 and 220, some special duties are now written here. So therefore it's a good change. That is one of the main objective of passing this law in 2007. One objective was clearly to simplify the legislative procedure. So it is almost achieved. Another objective was to make clear some of the rights, duties of the office bearer. Accordingly, term shareholder is defined. Director is interpreted. The director's duties are catalogued. Those are the another objective of passing this. So now it is written. So directors can clearly get a good idea what are their duties. But I don't know whether how many directors are aware of their duties. So if they are aware, you will understand. No one will be happy to be a director of a company. Right? There are such serious duties expected from man, from office. So that is why countries like Singapore, New Zealand, very hard to find the data. Because there are so many cases that they are in for breach of their data. If the directors are aware of their duties, things like Golden Key case, Colombo case, EPI case, never will happen. But those things happen because they are not aware of their proper duties. They exercise their duties, which is unlikely to happen after the event. And also, what is important is if they are found guilty for breach of their duties, they can be fined and there are criminal punishment as well. They can be imprisoned. Sometimes the company can get the compensation from the director. You know, in some companies, it's not thousands, maybe millions, billions, right? Therefore, it is not easy to act as the company director. So that is why in some countries, especially Singapore and New Zealand, very hard to find a company director in public company. They don't want to be directed. And those directors have consecutive meetings, workshops. They are regulated by their companies. Singapore, have a mass items and they go on the workshop. Mother expect one. In Srilanka, and this I think is deep, then copy of the director, one to register as a director, or non chapter of their Parancia, director, physical benefit. These are the duties expected from a content director. Then they have a fixed subject. To some extent, they will be seen about what is the role expected from them. So, however, yes, I'm sure that at least 50% directors are not aware of the duties expected from them. However, law is now very clear. The law clearly set out the duties of them. Directors' duties are also a major part of corporate governance. So, I'm thinking of having some guest lecture on corporate governance. So, then probably to have a thing on the group. So, there's a big, there's another thing can go. So, we are not in dual level, about 2 lessons behind you. But to speak corporate governance lecture, we can be together. We try whether we can have a online guest lecture about 2 hours, right? With the one of the corporate sector. So, I would like to have a comprehensive proper like John Kiso, and then we will try to discuss about the corporate governance, right? So, probably as we discussed in the 19th year, that is not a very weak, right? About 2 hours. Tomorrow, that's the but they expect something else for me to go up to a neck. And they will figure out and not again. If I put up a thing, someone had a lower story and come to the vehicle that is a fan place. These are actually they go with the other calculate on Salas, but probably they will pay next and then other 200 again. These are 200 again. Corporate governance or PSP. I'm going to dedicate a section it's like to have one guest lecture for one of those topics. So maybe 2 guest lectures also. Right. So director's duties is a major part of the corporate governance. When it comes to corporate governance, it's not from the director. It includes all the management, right? Auditors, faculties, accountants, and all. But director's duties is a part of only for the director, but that is important because this is a law. If there's a breach or break of duties, then the affected parties can file a case. But under the corporate governance, they are not laws. They are code, ethics. Even though there's a breach or break of those ethics, they cannot be punished. That's a difference, right? Maybe they can expel from the, or they can be delisted, but they cannot be punished. Ethics code they are punished. The maximum thing is it's a listed company, CSC can delist. But if there's a breach of their duties, it is the law, then they can be punished. They can make a law against. In some other Samaha may CSC because you can't punish it. In some Samaha, they go to the to break some of the rules of CSC is deemed to be breach of a Securities and Exchange Commission Act. Samaha rules SEC Act. So it is a law, then they can be passed. SEC Act is basically, yes, it's also important that it's passed in 2005. So that is important, especially for the limited companies. PSP is important for the listed companies. PSP is listed companies listed companies different. Lanka have a medical Manchigata listed. Okay, what we not listed. So they were the sector. In some different something that we can have one guest lecture those type of things. 5. So if you know one good person, just let us know, then please to call it. Corporate governance or CSC. PSC anyway, they will voluntarily do it because it's one of their objectives. PSC treatment right? Before Corona, I used to go with my students to CSC. One of their objectives to promote and to make the people about the awareness of the CSC. Then Corona now foreign companies can be listed and foreign companies can one. Small companies are make listed other like small and medium, like BOC, debenture foreign companies listed one Lanka. Development so anyway, yes, so yes, with all those things, so I am sure that they will be happy to have some of the lectures for especially the people like you. So therefore, we try to have some lecture. So if we have some relationship, so we can go there for one day. At the same time, we can go there and they will having their let's say their They have done all this stuff to make it public. I don't know what happened. One of my systems were like a public PLC got done the full as well. The PLC got done that. Okay, that's like association not for public. And then all steps were taken to make it public. Right. Unfortunately, none of you have shares. Or shareholders are direct shareholders. But we are all stakeholders of PSC. For the insurance member, insurance company in the capital market. Therefore, even though we don't have a direct share, we are stakeholders of the system market. Right. So, this is one of the common law duty of directors, and also now it is a statutory duty. Under section 187, directors have a duty to act in good faith for the company where they are a director. Right? So directors have a duty to act in good faith for the company as a whole where they are a director. Among director company, yes, for the betterment of the company, for the interest of the company, they have a duty to act in good faith. Among director in समाज में यहाँ पर बिजनेस सातवारी कर्म के लिए हुआ. So there were issues at the very beginning. This duty is towards whom? Whether it's towards the shareholders or it has more meaning than the shareholders. Towards the company. Yes, towards the company or shareholders. You believe it is towards the company. Well, I tell you what. That also depends on the merit of each case. There were some cases the judges have decided the director's duty to act in good faith is for the shareholder. Shareholder theory, stakeholder theory, agency theory, directors are only bound to maximize the profit for the shareholder. Therefore, their primary duty is to act in good faith for the betterment of the shareholder. Act says they are, yes, what does it say? The interest of the company. Interest of the company, right? If that the question means, what is the company? Whether the company means shareholders or all the stakeholders. How is that? How is that? Shareholder. Shareholder. This is like the argument, right? There are cases 50-50, right? Modern case always prefer company, but they prefer company means not only the share. Right? They clearly say some cases company definitely include creditors. It's not only the shareholders, it is towards the company. Company definitely include creditors. They justify saying that I have also communicated this to you. Shareholders are the owners of the solvent company. But in insolvent companies, owners are the creditors. Therefore, directors definitely have a duty to act in good faith, not only for the shareholder, but also for the creditors. Now it is more expanded. And now we say their duty is not limited to the shareholders or creditors. It also expands to all other stakeholders of the company. The most new development is that they have a duty even to the society and environment. Then good luck as a company even include the environment. There's a very recent case. In that case, court decided even in a wound up company, the board has a duty to feed the environment. Wind up company is not duty as environmental issues. You know, nowadays environment is a major issue. Right? Everyone talks about the sustainable development and corporate governance and all. Therefore, now company is a company, but company is said very widely, even to include the environment. Therefore, director duties towards the company, but company decided in some cases even to include the general society and the environment. Therefore, while we can accept their duties towards all the stakeholders of the company, including the environment. You all know that the environment cannot be there. Therefore, someone has to talk on behalf of the environment. Therefore, the company's duties include the environment. Right. Then, after one major reason for those fund as a company to come to fund like Sri Lanka is nothing but the environmental. Cheap labor, cheap land. Then in the following year, environment. This will come to the clear to now, or there are part. Only got one. Because environment thing of Marlon is because of your content, if you follow the environment, then lay out environment 100% happy. Water pollution and 100 liters, 100 liters feed water. Even the other thing double on the other. These are now very, very difficult for those developers to start this. There are so many environmental guidelines. That's a major part of the sustainable for sustainable today. Even talk about the sustainable economy, sustainable something. These are the company's duties not limited to the shareholder or even to the shareholders of creditors, even it's expanded to the environment. Right? So, a person exercising powers of performing duties as a director of a company shall act in good faith and in what that person believes to be in the interest of the company. So that is important, am I right? What that person believes to be in the interest of the company. Therefore, not what I believe, not what that believes, but what that director believes to be in the interest of the company. That's also good. Ne? They are business people. Ne? Ego is the Samani may have a idea. Ego is the judges, they don't know the business. Academics, they don't know business, but the business people, they know the business. Lanka, and they put the business सामान्य business क्या करना करता है दान then मंगी क्या ये पॉलिसी करता है या पॉलिसी करना हम तो वाली अरे नहीं एक आदमी का सेंट्रल बैंक के उनका वो business Lanka ini dia ini management kan pemahaman dia juga central bank gitu ini dia bisa fakta banyak bila dia sekarang juga terus dia betul utilization banyak dan kalau dia ini एक बार ada itu asal port pahal kita perlu kewa port dia हमारा तुलना है kayak alun gila port dah fakta berapa memang kita market price sebab berubah juga tapi dia pasti business people ini they know not business is from home discuss करना है business between देख और ये साधन तो लिखा है ना business ऐसा कोई इंसान नहीं public employee side of what कर क्या business is something employment is something इस बात से इतना है कि ना पंगी किया हुआ है कंपनी ना प्राप्ति में एक तीन वाले बाहर या फिर वहाँ होगा इधर तो लोग नहीं सीखने तो महाशय का भी ये है तब ये ओपन बनाते हो डिस्कस बनाते हो ये पब्लिक एम्प्लॉयज का केवल रास्ता बदले नहीं तो बांबड़ की मन प्राप्ति किया प्रॉपर्टी का अधिकार है तो मेरे कहना है इधर लोग कैसा ये बात ध्यान देना फिर मैं दिया था ना पोर्ट लिस्ट एंगल का ना तो बोलता नहीं करना ये एंगल का ना प्लीज तो वीडियो डाल दो they are the owners of the company. The insolvent companies owners are creditors. Mungi la porta hala. Kaya hala मतलब नहीं है क्या? ये तो जनता ने पाहरा कर दिया. क्या है नहीं? Business की तो profit loss बहुत नहीं. लेकिन तेरे नहीं लोग गुट्टी के बारे में क्या शेयर प्राइस के बारे में क्या करता है? रियलाइज करना तो देने का नहीं. ये लोग कुछ ना कुछ भी क्या नहीं. Right? लेकिन एक बार से देना है राइट तो करता है फिर तो कर देता है ठीक है कॉमन गुडविल लेकर आएगा और अब दिन तो लेकिन निकल जाता है ठीक है बड़ा तो हम कहां यहां 5 पैसे का है 4 पैसे का है दिन में दुकान का आता है दिन में तो दिया कहते पॉलिटिक्स का पास है ह्यूमन राइट केस पास है ना दे नेवर गो द बिहाइंड द कंप्लेंट ओवर माइक ये कैसे तो आप ऑर्डर करना ह्यूमन राइट ना politics of public command. But simply they can slogan the break the flow, break up their golden key case. Wind up until now the directors are trying to increase their remuneration and so those are clearly breach of their duty. Golden key cannot make a meeting. If the directors are given that, they even did list of their foreign to us. So they are clearly breach of their duty. Right. We discussed in under the winding up flow, our last topic. Right. So they have a duty to act in good faith for the company where they are a director, what they believe to be in the interest of the company. Now, what if say that there is a holding company and the subsidiary company. This subsidiary company is a fully owned company of holding company. So they say the holding company is A, subsidiary is B. Now A company appointed X as a director of B company to safeguard the IP. Is it clear? Now B will act for the betterment of each company. Okay, they don't just let you. Now A company appointed X of a B company is a fully owned subsidiary of A. B was appointed as a director. X was appointed as a director of B to safeguard their interest. Now in practice, B will act for the betterment of who? How do you manage it? How do you manage it? Practice. Low form of the will act for the betterment of A company. But according to the law, they should act for the betterment of the company where they are there. Among the electrolyte compare section 187. But this exception is also recognized by the provision to the 187. 187 is make right? Make a only 41 subsidy. 49 do not carry. 95 do not carry. Fully. At the moment, I case taken happy quick at the welcome. Taken more than 75 of the Gata. Even the biopsy, I'll go look. They have the 8 of the that's never done. That's fully on. Half not the betterment of B. Fully on that some fully on number make up the meeting up. You can fully on 51% not happening. Then you were towards the B. Where you are among the secretary after the command. The fully on the capital exception is the obvious. That's the only exception, am I right? In all other occasions, even though it is subsidiary, if it is not a fully owned subsidiary, then that they have to ask for the betterment of the company where he is a among in the company, fully owned capital makes the it is can be next. You have if answer the provide. Then he can ask for the betterment of the other one. These are 51% do not, 75% do not. Still they have to ask for the betterment of the company. Yeah, they are the thing. This is the only exception. If it is not clear whether the directors have not acted in good faith for the betterment of the company, because loss and profit is a part of business. Directors are recently got this company loss to not get that. If they have acted in good faith, even though company become bankrupt, still directors are not liable. We call it business judgment rule. Business judgment rule, because they are freedom, their innovative ideas should not be tested. Otherwise, directors won't get any decision. Therefore, if they can prove that they have acted in good faith for the betterment of the company, then they are not liable, even though company become bankrupt as a result of their judgment. It is called business judgment. Statutory. Then there's a good protection for the director. Then the director will take any action. There's no such protection. Sometimes directors will not go into some critical innovative decision. However, it is not sitting in any country until today, but judges will consider. Judges definitely will consider if they have acted in good faith, then they never will be liable. But only thing is they have to prove that they have acted in good faith. In good faith, the very well the court will use the reasonable man's test. Reasonable man. Meet me while we have phone. Even in the if the reasonable person accepts in that way, If the reasonable, just then we have accepted.